The gentleman reserves. The gentleman from North Carolina is recognized.
Thank you, Madam Speaker. On the other side of the aisle, we hear repeated references to the defending the Constitution and the American way. I would remind the chamber that our economy, the American economy, is built on contracts, which contracts under the rule of law are not forced but enforced. When someone refuses to abide by his or her agreement, that's not force. That's where a contract is enforced. Our courts, our judicial system, and yes, arbitration is the means by which we call people to live by their bargains. And that has been the key to the most successful economy in the history of the world. It has certainly been the state of affairs, as I said, for almost 100 years. Throwing that out, dispensing with a major component of that on the premise that you're pursuing the American system is contrary to fact. It is, as Democrats often seek to do, it is transformational. It seeks to transform America, not to reinforce and persist it. With that, Madam Speaker, I yield 3 minutes to the gentleman from California, Mr. McClintock.
The gentleman is recognized.
Madam Speaker, the gentleman is absolutely right. The bill purports to assert a very important constitutional right, the right to trial by jury in civil actions, but it does so by denying everyone a very important other constitutional right, the freedom of unimpaired contract, the right of two parties to agree to exchange goods and services according to their own best judgment. Now, because of the excesses and expenses and uncertainties that have plagued our civil courts, many consumers and producers and many employees and employers find it advantageous to waive their right to civil jury trials in any disputes between them in favor of a simpler, cheaper, and faster arbitration. Now, the proponents tell us that it's an uneven playing field. This requirement is often imposed in non-negotiable take-it-or-leave-it propositions. Well, this isn't exactly true. Every employee and every consumer, no matter how weak and vulnerable, has an absolute defense against a bad agreement. It's the word no. No, the pay isn't good enough. No, the price is too high. No, I don't like the binding arbitration clause or any other terms, and I'm taking my business elsewhere. Now, even when there aren't good alternatives, the fact is that every provision in a contract is a take-it-or-leave-it proposition if one side or the other insists on it. The question for each side is whether the totality of the contract is beneficial to them or not. It is every grown-up's right to make that decision for themselves without somebody in government making it for them. Remember, the so-called forced arbitration provision forces the company to accept arbitration as well. For example, I'm not a lawyer. I can't afford to hire one to take on a big company to court. For me, binding arbitration helps level the playing field by providing me with an inexpensive alternative that the company must abide by. This bill takes that protection away from me. According to the U.S. Chamber of Commerce, through arbitration, employees prevail 3 times more often, recover twice as much money, and resolve their claims more quickly than they could through litigation. And in most cases, the employer pays the entire cost of arbitration. According to one study, in claims between $10,000 and $75,000, the consumer claimant was charged an average of $219. Now, you compare that to the cost of hiring an attorney and taking on an entire corporate legal department. The net result of this bill will be higher prices for products and lower wages for workers, as companies factor the high cost of litigation into their business models. And, Madam Speaker, that's not fair. I yield back.
I thank the gentleman from California, and it causes me to remark, the gentleman from Tennessee said a moment ago that it's Democrats who look out for the interest of the little guy, they look out for the interest of the people. I wonder why it is that looking out for the interests of the people invariably involves restricting their freedom in some way. What a remarkable notion. And with that, Madam Speaker, I reserve the balance of my time.